All right, welcome back, Ethics in Medicine. Hope everyone's doing well. Today, we are going to be looking at decision making towards the end of life, including advanced directives, living wills, power of attorney. Should be pretty quick, but let's get going. So, reading from page 312, Advanced Directives are documents created by competent individuals to express their preferences regarding treatment should they become incompetent. The best known form of advance directive is the living will. The nation's first living will statute was enacted in California in 1976, prompted by the case of Karen Ann Quinlan, who slipped into a coma in April 1975. When it became clear she was in a persistent vegetative state, PVS, her parents sought to have her respirator removed. Her doctors refused, and her parents took the case to court. The court found that Karen, were she competent, would have had the right to refuse treatment, and held that Karen's guardian could assert that right on Karen's behalf, provided it was what she would have wanted to exercise in such circumstances. The problem was that Karen had never specified what she would want done. She was, after all, a healthy 21-year-old prior to her sudden loss of consciousness. Despite this lack of evidence for implementing the standard that has come to be known as the substituted judgment test, the court favored the right of Karen's family to make the decision to refuse her treatment. It stated that if their decision was that Karen would have wanted the treatment stopped, they could exercise Karen's right of privacy. The court found such a choice permissible based on the medical prognosis. Karen had lost all chance of returning to a sapient cognitive existence, suggested the hospital set up ethics committees to oversee such decisions, and in particular, confirm the prognosis. So, the Quinlan case prompted the enactment of the nation's first living will statute, California's Natural Death Act, in 1976. A living will is a document executed by a competent adult that directs medical treatment in the event of his or her future incapacitation. The California statute is very narrow. It allows the removal of life-sustaining treatment only after the patient has been diagnosed with a terminal illness that will cause death imminently. Thus, even though the statute was inspired by her story, it would not have helped Quinlan because she was not terminally ill. Indeed, she continued to live another 10 years after being taken off the respirator. So that was the substituted judgment standard. So it's not that the parents can take it out if it's what they would want for her. They can only take it out if it's what she would have wanted for herself. Yeah. Well, then came along the Nancy Cruzan case. Another woman who entered PVS after a car accident. Like Karen, Cruzan did not die when removed from the respirator, but continued to breathe on her own and was placed on a feeding tube. After 4 years, when it became apparent that her condition would not change, her father attempted to have the feeding tube removed so she could die. Nancy's parents were granted permission by a Missouri trial court to terminate her artificial nutrition and hydration, but the Missouri Supreme Court reversed the decision on the grounds that there was not clear and convincing evidence that she would have wanted the feeding tube removed. Right? So they're like, okay, we still use substituted judgment, but we have a different standard of what constitutes. You have to show clear and convincing evidence that this is what she would have wanted, right? So it's like states' rights game. The U.S. Supreme Court upheld the judgment of the Missouri Supreme Court. This was the first so-called right to die case. The court made two notable claims in Cruzan. First, it rejected the view that there is a moral or legal difference between taking someone off a respirator and removing a feeding tube. The court said that in the context, they are both forms of medical treatment, and thus both can be rejected. Second, the court upheld the Missouri's right to use the most stringent standard, the clear and convincing evidence standard, in determining whether life-prolonging treatment could be removed from incompetence. The court did not say that this standard must be used, only that there is nothing in the Constitution that prevents a state from applying this test. Well, at this point, other people came forward who had known Nancy Cruzan by her married name of Davis, and so didn't connect her with the case until they heard the details. They had worked with her in a program for children with disabilities where she had stated repeatedly that she would not want to be force-fed or kept alive on a machine. Same here. The Cruzans returned to court with this testimony in 1990, and this time the Attorney General and the court-appointed guardian ad litem did not object to the Cruzans' request. The judge who had immediately ordered that said the tube The judge who had originally said that the tube could be removed repeated his findings of 3 years before. It was removed, she died. Living wills are intended to provide a clear and convincing evidence of what the person would have wanted, thus providing a basis for proxy decision making. However, most Americans do not make living wills, only 21% of them. The problem with living wills is that it's extremely difficult to see every medical problem and possible treatment that might arise. Living wills also require physicians to make treatment decisions based on their interpretations of the document rather than on a discussion of the treatment options with a person acting on the patient's behalf. So you can see there's a lot of benefit to having some statements of what your wishes are should you go incompetent or unconscious and can't express yourself. I mean, you could call it a living hell to be stuck in a state that you can't control, end of life. But there are some problems with living wills. I'm not having you read it, but at the beginning of Section 2, Advanced Directives, there's enough, the failure of the living will. And if you're interested, I'd urge you to we're going to look at a couple cases of why it's so hard to predict what you're going to want in some future situation, because you just don't have very much information about that situation. But we ask an obvious but unasked question. What would it take for a regimen of living wills to function as their advocates hope? First, people must have the living wills. Only like 29% of people have wills. Second, they must decide what treatment they would want if incompetent. Third, they must accurately and lucidly state that preference. Fourth, their living wills must be available to people making decisions for the patient. Often it's with a lawyer, it's not at the hospital. Fifth, those people must grasp and heed the living will's instructions. You'd be surprised at the amount of physicians who ignore living wills. And so they make a case in here that literally none of those conditions can be met. And that they're an extreme raise in cost and other issues. Yeah. And so the flip side of living wills is durable power of attorney for healthcare. And really, I recommend both, although you can read the argument against living wills and make the choice for yourself. As you can see, I have attached some links because I think both there's problems with leaning too much on one or the other, in my opinion. But patients anxious to control future medical decisions should be told about durable power of attorney. These surely do not guarantee patients that their wishes will blossom into fact, but nothing does. What matters is that the powers of attorney have advantages over living wills. First, the choices that powers of attorney demand of patients are relatively few, familiar, and simple. Second, a regimen of powers of attorney requires little change from current practice in which family members ordinarily act informally for incompetent patients. Third, powers of attorney probably improve decisions for patients since surrogates know more at the time of the decision than patients can know in advance. Fourth, powers of attorney are cheap. They require only a simple form easily filled out with little advice. Fifth, powers of attorney can be supplemented by legislation already enforced in some states, akin to statutes of intestacy. Just fact checking myself, intestacy is basically when someone dies without a will and like a probate court has to figure out where the remaining property and goods goes. So it's like if they have more property than they have debts, otherwise those debts would be satisfied by the probate court. Basically, dying with intestacy is dying without a will in place. So, long story short, they push hard for power of attorney. Just to go over a couple situations that I thought were remarkably thought provoking. See what you guys think. So, and this is on page 366 of our textbook. I just tracked it down online. What is this thing? How do I move this thing? Get out of my space. The worst. Okay. So, the following scenarios: imagine that all patients were 50 years old at the time of making an advance directive and that critical medical decisions are confronted 5 years later. Assume also that no evidence exists that the patient changed his mind or wavered in resolve between that's better. Between preparation of the advance directive and losing competence. I got it, folks. Hang in there. Person A Jehovah's Witness, prescribes an advance directive that blood transfusions should not be administered regardless of the life-saving potential of such medical intervention. A is aware of the life and death implications of this religiously motivated instruction. Later, A becomes prematurely senile and incompetent. Still later, the senile patient develops bleeding ulcers, which demand blood transfusions. With a blood transfusion, patient A will survive and continue to live as a pleasantly senile person for a number of years. Love pleasantly senile. The senile A no longer has recollection of or interest in religion. However, she remained an avid Jehovah's Witness up until the time of incompetency, should the attending physician administer a life-saving blood transfusion. So this is interesting, right? She's senile. She doesn't remember being a Jehovah's Witness. She has no recollection of it. As far as she's concerned, I mean, now she is not religious. She was upright. Do you still withhold treatment for something for a faith that she no longer possesses? Well, I wish we were in class and you could discuss it with each other. But be interested to see if anyone writes up on it. Love it. We're going to skip that one first. Person C is an individual with chronic heart problems. Physicians have informed person C that at some point he will need a heart transplant in order to survive. He prepares an advance directive stating that if he becomes incompetent and survival becomes dependent on a heart transplant, then such a heart transplant should be rejected because of its expense. He would prefer to leave a substantial monetary legacy to his children, chunk of cash. Later, C becomes prematurely senile and incompetent. Still later, his heart deteriorates, and guess what? A heart transplant becomes necessary to preserve C's life. With the transplant, he will very likely continue to live for 3 to 5 years. Without it, he will die within a few months. The transplant will cost $100,000 and is not covered by any insurance. His estate totals $100,000 should the life-extending heart transplant be performed. He no longer has the recollection of his wishes before. It's his property. Should you do the thing, right? Oh, this one's fun. Person D is a healthcare professional sensitive to society's needs for organ and tissue donations, as are you now. In her advance directive, D provides that if she should become incompetent but remain physically healthy, then she wishes to donate a kidney and bone marrow to needy recipients. Later, D is afflicted with Alzheimer's disease and reaches a point of profound dementia. Needy recipients for kidney and bone marrow transplants have been located. The prospective transplant operations will pose only a slight risk to D and entail only mild pain. At the same time, the now incompetent D has no recollection of her prior instruction and no appreciation of the altruism involved in donating an organ or tissue. She will derive no contemporaneous gain from the contemplated operations, should the transplants be performed in accordance with D's advance directive. So I really want you beautiful humans out there watching this, to think about if you're being consistent. If you're saying always follow the advance directive, don't change it, withhold the blood transfusion, withhold the heart, in this case, you would be performing surgery on someone who might refuse it now and be like totally stunned and freaked out, mild pain. Well, if it's pain you don't understand, that's a lot of pain, right? So are you a true just hard and fast, or would you ignore the advance directive and do something different? Most like half of doctors admit to ignoring advance directives or living wills. Okay. Rambling. I'll finish with this one. This one's always a kicker. Those of you who are all about respecting the advance directive, love it. Excuse me. Person B believes both, that life should be preserved to the maximum extent possible and suffering is preordained and carries redemptive value in an afterlife. B prepares an advance directive in which all possible life-extending medical intervention is requested and all pain relief is rejected. At the time of the preparation of the directive, B has a conversation with the physician in which the physician explicitly warns B that many terminal illnesses entail excruciating pain. Despite that admonition, B directs that all means to preserve life be utilized and that analgesics, painkillers, be omitted. Subsequently, B suffers from cancer, which both affects his brain, rendering B incompetent, and causes B to suffer excruciating pain. Further medical treatments, such as radiation or chemotherapy, will extend B's life, but will not itself relieve the pain or cause any remission in which competence would return. Should the attending physician sedate the patient and cease the life-prolonging medical interventions, or both? So, wow, what would you do? You're gonna respect that advance directive? Put him through chemo and radiation with no pain relief? Are you kidding? And he's just confused and screaming and respecting the former autonomy? I mean, what is your duty as a healthcare worker? A nurse in my class once was like, oh, hell no, I would, that's just sadistic. Like, of course you're going to sedate him. You're not going to respect that advance directive. It's crazy. But who are you to decide what they need, what's right for them, what's best for them? So, let you mull on that. So, we've looked at advance directives, living wills, durable power of attorney. For write-ups, I got links to doing your own Wisconsin power of or living will. And if you want to do one of those and submit it as your, you don't have to fill out all the particular stuff because I, really don't care about your personal information or who your people are. But like thinking through some of the questions in here, for instance, where are you? So you put all this stuff, power of attorney, and then you express your wishes, if I can ever get to it. Admission to nursing home, provision of a feeding tube, under what circumstances. So you literally get to specify your choices. Do you want to be kept alive via artificial respiration or feeding tube? In what situation? What happens if I'm pregnant? All these, as many situations as they can entail. And while again, there's plenty of situations, as we said, where you just can't really predict how situations will change and who you'll be in the future. What happens if I have a terminal condition, right? Persist a PVS condition, right? Which life-sustaining or life-preserving measures would I want? And so that'll be an option. I'll also let you have Ms. Erickson. You can analyze that one. Or another one that goes to the right to not only refuse treatment, but to the right to end your own life. Like, I think most of us at this point are pretty okay with the idea of a person with a terminal illness wanting to end their own life. But there is a really fascinating case study that we have on page 462, and it's about Miss Boomsma, who basically wants to take her own life and gets help in the end because she's lost both her sons died, and she basically lived for her sons. And so basically out of grief, not even grief, but just her mission and purpose in life was gone. And so it's a very fascinating situation to look at if you want to take that pursuit. So I'll give a couple options. Thanks for hanging with me, everybody, and we will do medical experimentation next time.